Think you can walk away from a deal based on your finding that the house was previously a marijuana grow-up house, or you can rescind your deal after you firm up on the property. In this case, the buyer lost the deposit and he ended up owing tens of thousands of dollars to the seller once he discovered the house was previously a marijuana grow-up. And here is the real Ontario Court of Appeal case which every home buyer and seller need to know. So here is the background. A Toronto buyer agreed to buy a house worth $916,000 and he put $30,000 deposit. To make the offer more competitive, the buyer removed the condition of inspection and submitted an unconditional offer. After the agreement was signed, the buyer did some research and discovered that the home was previously used as a marijuana grow-up back in 2004 by the previous homeowner. The buyer immediately refused to close and demanded the deposit back. Sounds reasonable, right? Wrong. The case went all the way to Ontario Court of Appeal and the court ruled in the favor of seller. Why? Because in our standard Ontario Real Estate Association agreement, it says the property has never been used to grow illegal substances to the best of seller's knowledge. The seller honestly did not know the home's history when they signed this agreement. That meant there was no misrepresentation on the part of the sellers. The buyer was the one found in breach of the contract. Here is what it cost him. Loss of $30,000 deposit. The seller later sold the house for $86,000 less and buyer was potentially responsible for that loss too. So here is the lesson. Ontario follows the principle of buyers beware. A former grow-up is generally considered a psychological stigma, not necessarily a physical defect. That means if after you signed an unconditional offer, usually did not give you the right to walk away. So before removing any conditions, always do your due diligence. Research the property history, get a professional home inspection, ask a lot of questions. If the property history matters to you, negotiate a stronger warranty in the agreement of sale and purchase, because this one clause in the contract can cost or save you tens of thousands of dollars. So now expanding on what I just mentioned, here is the key Ontario real estate law principles. I repeat again. First is buyers beware. It's called caveat emptor. Ontario generally follows this principle of buyer beware, meaning buyers are responsible for investigating a property's history before they make an unconditional offer. Second, stigma versus physical defect. A former marijuana grow-up is generally considered a psychological stigma, not automatically a physical defect. A stigma alone usually does not allow buyer to cancel an APS. Just to let you know guys, I'm real estate broker, I'm not a lawyer. If you are in a situation, please seek legal counsel. Now moving to the third one, seller's duty to disclose. Sellers must disclose hidden physical defects, dangerous conditions, defects making property unfit for habitation. Fourth, meaning of to the best of my knowledge clause. This phrase in this case protect the sellers who honestly lack any knowledge from the previous owner's ownership. It does not guarantee that no historical event occur. So lessons for the buyer: do your due diligence before signing, research local police records, online history, municipal permits, insurance claims, prior MLS listings. Never assume the standard Ontario Real Estate Association clause is a guarantee. It only reflects the seller's knowledge. Consider home inspection, environmental inspections where appropriate, additional investigation before removing any condition, and always put strong wording. If the property history is important to you, request an unqualified warranty such as seller warrants the property has been never used for production and cultivation of illegal substances. Understand the risk of unconditional offer. Once your conditions are waived, walking away can lead to loss of deposit, damages, legal cost, lawsuits. And here is the lesson for the sellers. Answer all the questions honestly. Never guess or speculate. Only represent the facts that you actually know. And if you later discover information, seek legal advice immediately before closing. Do not assume you must terminate the agreement. And keep records. If you're a seller, did renovation, keep all the renovation permits, insurance claim, remediation reports, and environmental reports. And use the standard Ontario Real Estate Association clauses very carefully. The phrase "to the best of seller's knowledge" provides important legal protection where statements are made honestly. So in this case, the key takeaway is any unconditional agreement of sale and purchase is difficult for a buyer to escape. A buyer cannot simply walk away because they later discover a property was stigmatized, and if the seller honestly in this case has no knowledge of it when this agreement was signed. So this case highlights the importance of buyer's due diligence, carefully reviewing all the representation and warranties and understanding the standard agreement. Thanks for watching my video. If you have any questions in regards to real estate, reach out to me at 647-961-2639. And if you're a first time viewer watching my video, subscribe me on TikTok, Facebook, and Instagram. Thank you.